Good morning and welcome. I'm Rick Oldenburg, Executive Director of the South Sound Plan Giving Council and co-chair of Leave 10 South Sound. And my other co-chair, my better half, Evelyn Ryberg is here. Evelyn, if you'll wave. Evelyn recently retired as Senior Director of Philanthropy at Greater Tacoma Community Foundation. We really want to thank everyone for coming today. Right now, we are in the midst of one of the most important weeks of the year for families. In 2008, Resolution 1499 was passed by Congress, which proclaimed the third week of October as National Estate Planning Awareness Week. That's important because not having a will or estate plan creates chaos, uncertainty, and unnecessary family pain if a person dies without indicating how they want their possessions divided or disposed of. Now, here's a terrible statistic, and I'm embarrassed to say this. Nationally, less than 40% of Americans have a will, and many of those are outdated or invalid due to changes in tax laws and regulations. That means more than 60% of families will have to deal with a loved one's death using a will written for them by the state where the decedent lives. I'll bet if you looked at the way state of Washington would divide your estate, you more than likely would not agree with all the things they've made as a decision on your behalf. And it doesn't have to be that way. It just takes a little time. It's been estimated that a person spends 45 years, about 95,000 hours, building their wealth, and sadly, less than 4 hours deciding where and how to leave it. So, as a colleague recently wrote, confronting one's own mortality or that of a loved one can be intimidating. That said, failing to do so can harm your family, rob you of the opportunity to direct what happens to your possessions, and deprive yourself of having some of the most meaningful conversations of your entire life with those you love the most. So that's why Leave 10 South Sound is sponsoring this session on basic estate planning. It is entitled Securing Your Wishes. Where there's a will, there's a way. And the concept of Leave 10 is really simple. Leave 10% behind to invest back into the community through the nonprofits and causes you supported while alive. After all, none of us got here on our own. We didn't build the school systems, the universities that taught us. We didn't create the businesses that gave us our start in becoming self-sufficient, or the democracy we were lucky enough to be born into. Now, that was all done by people we'll never know, long before we arrived. So Leave 10 South Sound encourages each person to find the things that resonate in their life. And by participating in person now and leaving something behind later, help build the world into something that's a little better than the way we found it. So Leave 10 is ably run by 26 community volunteers made up of nonprofits, professional advisors, that's attorneys, CPAs, financial planners, trust officers, etc., and local donors who represent Pierce, Thurston, South Mason, and North Lewis counties. They are an amazing group doing equally amazing work in their communities. Here are the protocols for today's meeting. Please keep your microphones on mute. Drop your questions into chat. Our digital Wonder Woman, Melissa McCarthy. Melissa, wave your hand, please. She will monitor the chat and assist us in getting your questions asked. So we'll begin with the basics of estate planning, and then at about 12:30, we'll bring in a panel of professional advisors to help answer your questions. You will have a great deal of expertise at your disposal for about 25 minutes, so I hope you take good advantage of that. Today, we are excited to have a veteran and Tacoma estate planning attorney, Brianne Kampbell, who will explain the basics of estate planning in a way that is understandable and up to date. She was born and raised around Puget Sound, received her bachelor's in English literature from the University of Portland, and graduated cum laude from Seattle University School of Law. She runs a thriving legal practice and has specialized in estate planning for more than 20 years. So very happy, Leave 10 South, very proud to introduce you to Brianne Kampbell. Brianne.
Thanks, Rick. Should I say dad? If any of you don't know, Rick is my dad. So thank you for that glowing introduction. I really appreciate it. And as I told the panelists before we got started, I don't use slides a ton, so you're going to bear with me today as I deal with the slides for the presentation. So I'm going to go ahead and get that started right now. And let's see. Okay, is everyone seeing my screen at this point? Okay, perfect. So today I get to talk to you about the basics of estate planning, and I think there's a few people here that have heard me talk about this before, and I'm going to cover a lot of the same material because the basics are always the basics. And so last time I did this presentation, I took some things out in the interest of time. This time I put them back in again. And so if you notice that I'm going a little bit at a quicker clip this time, that's probably why. And so here we go. Basics of estate planning, things that every single person needs to know. Just a tiny little bit about me. Rick already told you that I'm a local girl. I grew up around here, went to Bellarmine Prep, went to law school in Seattle. I'm a regular person too, in addition to being an attorney. I've got 2 kids. One just started high school at Bellarmine, which is what a mind trip that is when you have a kid who's going to the same school that you went to too. But I think it's important for you to know too that I am an estate planning attorney, but my whole mission in my practice is to make estate planning accessible for everyone. So accessible in that you can afford it, accessible in that you have someone to talk to who's not intimidating, who will break things down and make it understandable. Because I think a lot of the reason why we have the problem that Rick was talking about with, a big part of our population not having their estate planning done is that it can be an intimidating process for people. People don't know who to talk to. They don't know the questions to ask. And so the goal of my presentation today is to arm you with the basics. Whether you're an advisor who talks to people and maybe people ask you questions, or you're in a position to refer clients to attorneys or to services that can help them get their estate planning done, or you're in a position simply to raise the idea of estate planning with people. And if you're not a professional advisor and you're here and you're just a person, hopefully this is good information for you. It arms you with things to talk about with family members, if you know you have family members who don't have their estate planning done, because we really all need an estate plan. So when I talk about estate planning, what does that even mean? Most people have heard that term and they don't actually know. I think sometimes people think that estate planning means financial planning. I think sometimes people are right on the nose and think it means a will. But when I talk about estate planning, it's kind of a universe of things. So the main and largest component of estate planning for estate planning attorneys is a set of documents. The documents are things that you're probably really familiar with already, but they all work together. So we're going to talk about all the documents in just a second, but like a will, that's part of an estate plan, right? Estate planning also encompasses other things too, though. It includes tax planning. If you have any type of estate tax issues or capital gains type tax issues, those things are under the umbrella of estate planning. Estate planning encompasses planning for incapacity. So not just what will happen to my stuff when I die, but what will happen to me if I'm alive and I can't make decisions. So that's something that we talk about. A major pain point for people, and something that I think gets them in the door to talk about estate planning, is planning for family members. So let's say you have a minor child and you're worried that something might happen to you and a guardian needs to be appointed. That's a big reason for people to get their estate planning done. The universe of estate planning also is wanting to make sure that all of your things work together. So your estate planning documents work together with your tax plan, work together with your financial picture, work together with what your overall objectives are for your family. It's just kind of putting all these pieces together, and also making sure that your objectives can actually happen. So estate planning is the practice of taking your ideas and thoughts and philosophies and making them concrete and giving them a pathway to success. That's what I consider to be estate planning. Who needs estate planning? So I have heard a lot of people say like, oh, I don't really need a will because I don't really have anything. Well, the real simple answer is every single person needs an estate plan. You could be ultra wealthy, you could have nothing. You could have children, you could have no children. You could be single, you could be married, and you would still, in any of those situations, need to have an estate plan. One of the main reasons is just what Rick identified at the beginning too, which is if you don't have a plan, then our state has created a structure that will be your plan, and that plan may not be what you want it to be. But just to quickly touch on it, if you don't have a ton of money, An estate plan is also really important because it means that your estate can be administered more efficiently, and that means it will save your estate money. If you're wealthy, you probably have tax issues to consider, and that's something that needs to be planned around. If you've got children, we need to plan for them if something happens to you. If you don't have children, then that one size fits all RCW that talks about what happens to your estate if something happens to you may really not fit you at all. And if you're married, then you want to make sure that you're providing for your spouse kind of in all the ways that you possibly can. So I hear the funniest rumors in my practice. I have people come in and say things to me, and I try to jot them all down because I think they're pretty funny. But the sad part of the funny is that a lot of people hear them and believe them. So some of the main kind of categories of rumors that I hear is, I've already said it, I don't need a will because I really don't own anything and I don't really care what happens. I don't need a will because I'm married and our state is a community property state. I don't need a will because I don't have any kids, whatever. I don't really care. I don't need a will, or I don't need to see an attorney because I can just handwrite my will or make a video, right? I can just make a video of what I want. I have people come in and say, well, I absolutely need to have a trust, talk me out of it. Or I heard Susie Orman saying that I need to have a trust. People come in and say probate is horrible. I want to do anything to avoid probate. People come in and say only rich people do estate planning. If I don't do a will, the state will get all my money, or the government will get all my money. And then why does it matter? I'll be dead anyway. These are all things that I hear on a regular basis. And hopefully by the end of this presentation, you'll understand that every single one of these things is not a true statement. But I bet you, if I ask for a show of hands, I bet each and every one of you have heard different iterations of all of these things, just in talking to friends and neighbors and your nephew. I mean, that's kind of where we get all our important information, isn't it? From people who are not connected to the field in which they're giving you advice in. Okay, but let's just get back to it. So again, I've touched on some of this already. Why is the plan important? Well, it's the roadmap for people to follow if you're not able to say what you want them to know, right? And that's really important. We go through life, we make a ton of decisions, we take great pride in our decisions. It's not cool to leave it at the end and not have made these decisions or leave a roadmap for people to follow. A plan is important because you get to decide who gets your stuff, and you get to decide who's going to be in charge. And those are two kind of important things for people that they really want to be in charge of making that decision for themselves. And an estate plan is the way to do that. A plan will make the process simpler and less expensive, whether your estate goes through probate or not. And again, we'll talk about probate in a little bit. Having a plan will mean that the process costs less money, no matter which way you cut it. It will make sure that people that you want to take care of in a certain way can be taken care of in that way. It can make sure that if you have organizations that you support and you believe in and you make, annual donations to, when you're part of their circle, it means that you can continue supporting them or leave a legacy bequest to them after something has happened to you. Whereas if you don't have an estate plan, that's a pretty unlikely scenario for your family to carry out without being instructed to do it. And then, of course, there's always tax considerations with estate planning. We can minimize the tax that your estate might have to pay. Why do we avoid it? Why do people avoid this process? Again, kind of like with the rumors, they're just things that I am constantly hearing. I think the biggest why do we avoid it is procrastination. It's just something that feels like that is way down the road and I don't need to deal with that. I'll just, today I'm busy. I'm going to think about that tomorrow. Procrastination. People don't know who to talk to. So that's a really common thing I hear from people too, is that they don't even know where to start. They don't know any attorneys. They don't know who to ask. They don't know what questions to ask. People are intimidated by meeting with an attorney and feel like because they're not an expert at estate planning, they're not going to ask the right questions or understand. They've heard rumors or misinformation about the process. And so they're just like, that sounds messy. I don't really want to get involved in that. Estate planning can feel complicated and overwhelming too. If you're just like, whoa, I'm going to have to make a ton of decisions. I'm going to have to do homework about my estate. I'm going to have to look at my financial picture. I'm going to have to think about taxes. And a lot of those things are things that we just say yuck about, right? Like, ugh, I don't want to think about that. I don't want to do that. It's overwhelming. Nobody wants to think about their mortality. That's the truth. Nobody wants to think about their family's mortality, what would happen to their kids if they weren't around, because it's just a really sad, depressing thing to think about. And then we all have fear too, right? So one of the things I face is like this superstition that people have, which is kind of funny, but like if I get my estate planning done, then maybe I'll die the next day afterwards or something. But I always look at it as the opposite. You put an umbrella in your car because you think it might rain, and then it doesn't rain. You never need the umbrella, whatever. Estate planning is kind of a similar thing. When you're done, you're going to have peace of mind, and it has zero impact on whether you die the next day or not. It's just there if you need it and your family has a plan. So at the heart of estate planning, like I talked about, are the documents that we prepare to put the roadmap into place for you. And the main documents of an estate plan are always going to be a will or a living trust. Most people are served very well with a will. Sometimes people need a living trust. For right now, it's important for you to know that they both serve the same purpose after you die. So after you die, they say who should be in charge, and they say what should happen to your things. And that's the gist of it. Whether a will or a trust is better for you, we'll talk a little bit about that in a minute. But at the foundation, this is the most important document that governs after something has happened to you. The other documents that make up the set of documents for estate planning are a power of attorney. So that's a document naming someone to step in and make decisions for you if you're alive, but you can't make decisions for yourself. It's important to understand that the will and the power of attorney do not overlap. So a power of attorney is valid while you are alive if you need help and you're not able to make decisions for yourself. If you die, the power of attorney is terminated and your will takes over from there. So they don't overlap, they just come right up to each other. But they both provide guidance about who should be in charge of making decisions for you or for your estate. Next, we have the healthcare directive. Some people call this a living will. It's called an advanced health directive. You've kind of heard it referred to in multiple ways, but they all do the same thing. That document is a statement about if something happens to me and I'm at the very, very end stages of life, what kind of end of life care do I want my agent, named in my power of attorney, to decide for me? Should they just keep me alive kind of indefinitely, or should I be permitted to pass away and be comfortable? That's the whole purpose of that document. It's very, very short and to the point, and you make your own decision about what you want. And then finally, we come to round out the fun, the disposition of remains. That's a statement that you can make about if you prefer cremation, burial. Composting is a really kind of hot new way out of this world. But it lets you decide what you want. It doesn't mean that you've made arrangements to do it. It just means that that's what you want, and a funeral home can honor your wishes without kind of finding every person who's closely related to you to sign off on that disposition method. So those are the main foundations of an estate plan. We're going to talk about a will and trust for just a minute. So what is the main job? You probably already know just by being a living, breathing person, but a will is going to name the person who should be your executor. The executor is the person who, after you pass away, figures out what you have, handles probate if that has to happen, figures out taxes, and just takes control of your estate to wrap up all the loose ends and then close it out. They're the person in charge. The will is also the only document in Washington, at least, where you can name a guardian for minor children. So if you have little kids and you're concerned you and your spouse are traveling together and that's the reason you're in doing your estate plan, the guardianship part for your children is going to show up in the will or the trust. It also lets you designate how you want your estate to pass. So who should get what? How should they get it? The how should they get it part also lets you say, if you have people who are beneficiaries of yours who, let's say, aren't very strong with money and need a little bit of assistance, we can provide for a trust that way. If you have people in your life who have disabilities or receive government benefits, and you want them to benefit from you, but you also don't want to hurt their ability to receive benefits, that's something that we can do in a will or a trust also. A will and or trust and all of your estate planning documents should also involve a lot of alternate plans. So here's my primary plan, but if this doesn't work out, or if this person has passed away, here's my alternate answer for that. And if something has happened and this doesn't work out, here's my other alternate answer. So when you meet with an attorney, when you're going through this process, you are going to hear a lot of, okay, and then what would be, if this couldn't work out, what would be the next right answer for you? Because it is a very true fact that most people don't have estate planning, but of the people who do have it, they're not apt to come and update it very frequently, even though that's the recommendation. So what we want to do when we put your plan together is plan for the worst case scenario of, maybe many years have gone by before these documents are effective. And we want to put as many alternates in place that it would still be effective if something happened to you and you had never updated it. At least we would have some answers or some options there. So that's kind of the thinking of the document. And then finally, and an important one for probably a lot of people who are attending this webinar, is that a will or a trust can let you provide for a charitable organization that you care about. So if you don't have a plan, the law definitely doesn't include your favorite charity on the list of people who should get your estate. It's going to be a combination of family members, depending on how close the kinship is to you. And a lot of times people will tell me like, oh, I don't need to put in that bequest to a charity because my kids will just take care of it. They know that I support, South Sound Plan Giving Council, and I'm really involved there and I give every year. So I know that when I die, they'll make sure to do something for them. Well, I can tell you from experience that if you haven't written it into your will or your trust, the likelihood of a family member, no matter how well-intentioned, no matter how loving, no matter how much they understand you, of making on their own a gift to a charitable organization that you cared about is pretty slim. And if they do, it might not be the type of gift that you would want to make, that you would feel good about. So the will is the place to do that. Another big question that I have from people with regards to wills, and I think also sometimes is an impediment to them doing their will, is having a hard time deciding who should be the executor or the trustee. So a lot of times people will say, well, I don't really trust anybody, or I don't have anyone close to me who could do that job. And then they kind of just let it stall out. So I think it's important to kind of talk about a few of the things that can go through your head or help you make a decision about coming up with an executor or a trustee. So you have one main decision. Are you going to name a person that you know to be the executor, or are you going to name a professional fiduciary type company to be the executor? And I'd say it used to be really rare that people would be considering having the professional serve as the executor, but over the years, it's become more and more common as people understand several things about estate planning and wills and probate. And the first and foremost is that when you die and someone steps in to take over your estate, it's like not a kindness to name someone else to be your executor. It's, it means you trust them. So I guess that's flattering, but it's also a really big job. And in addition to being a big job that most people don't have the training to do, it also carries a lot of liability with it. So the person that you name not only now has an extra job that they're doing, but they also are carrying liability if they mess up. And that liability typically would stay with the estate, but if they've done something, it can also exceed the bounds of the estate and attach to them personally. And so if you're naming a person to be the executor, which again, still the majority of people name, their spouse, their child, their friend, their CPA to be the executor, that's fine. But you do want to make sure that you're picking someone who can be detail oriented, who was like a type A, good student kind of person, who's not going to just do half the job and then say, the C+ is good enough in this case. No, we really do need to do the A work for this type of job. So you want to look for that type of person. But the alternative to that is naming a professional company to do it. There's a few around that do a great job. But kind of the cost benefit analysis there, or the benefit of having a professional, is that they typically have liability insurance. They have the training and the expertise to do the job probably more efficiently than just a regular person would do it. They have extra people around, so if something happens to one person in the organization, they've got other people to fall back on or people to ask questions to. If that organization goes out of business, almost always it's been taken over by somebody else who can do the same job. So there are some things to think about there. One of the main, I think, components for people is what it will cost them, and that's kind of how they make the decision. When you hire a person or you name a person who is known to you, they often won't charge for their services to be the executor, although it's important to know that you can charge for your services. So the law always provides that if you're serving as an executor, you can pay yourself for that job. If you're hiring a company, they're going to have more a professional rate schedule for what they do, but they may be more efficient with their time. So, it's kind of a toss up there. People always ask me if they can name, all 4 of their kids to be the executor at the same time. And I always have the same advice, and that is, if you can choose one and then another and then another and then another in priority order, that is that is practically easier for everybody. And it also means that there is one person who can sign off on everything without having to have multiple people sign off on things. Now, that doesn't mean that the one person that you name should just take action and just leave everybody else out. When you've got, let's say, a child who's acting as an executor and you have multiple children, when I'm the attorney who's representing the executor, I'm always saying, have you talked to your siblings about this? Let's give them notice of what you're thinking. Let's give them a time period to respond to us, to let us know if there's a problem. Most people are doing that informally. But just from a practical naming an executor perspective, you can name multiple people at the same time. It's not my recommendation. When you're working with banks and you have to set up an estate bank account, it can be very difficult. Banks typically don't like to have multiple people in a position of power, where then somebody might do something without someone else's permission, and then the bank is worrying about their own liability. So from a practical perspective, it's better to appoint one person, but we have people who sometimes will appoint multiple, and we can make it work no matter what. When you're thinking of naming an executor, we already talked about this, but you definitely want to think about the abilities of the person that you're naming. Is this something that's in their wheelhouse, or is this like, you've got a son who's very artistic and they're not that type of brain, and this is going to be really stressful for them, and they're going to be really upset at that time period. Maybe that's not the right person. So you just want to think about the abilities. And then finally, I think we've kind of talked about this now, but the reality of the job. It's not like an award that you're winning when you get appointed as an executor. It's a job. And a lot of my clients, they get through the process as the executor, but they're like, this was a lot of work. So just be mindful of that when you're naming people. And then a side note that I didn't put on here, if you're naming a person to be your executor, you also have to know that that person does not have a criminal record, because if they've ever been convicted of a crime, they will not be permitted by the court to serve as an executor. So you should just know that right off the top before you start naming people, because that can get really cumbersome too when we're trying to get somebody officially appointed by the court. And then how do you provide for minor children? So your will is the place that you can name a guardian for your children. You can say who should have them first. If that person can't do it, who should be next? Lots of times people are naming couples to serve as guardians for their children. And so you always want to be clear, if you're naming a couple, if something happened to either spouse in the couple, would the other person be okay on their own? If the answer is no, then you just want to name the other person and then have some alternate people after that, so that we can follow a very good progression of that. You can also, in your will or your trust, provide for the financial care of your kids. And that could be with somebody different than the person who has physical custody of them. So maybe they live with one person, and then money that's coming to your kids, we set up into a trust with terms that work for you. The trust holds the funds for the kids until they reach a certain age that you think is appropriate. So maybe it's 25, maybe it's 30, maybe it's, we're going to make some distributions along the way to kind of get them used to finances. We can create whatever structure you want. Typically, a trust is a better option for minors than just saying nothing about what they inherit. If you say nothing, then a court gets to decide how they get the money. And if a court decides, the money usually goes into a blocked account until they reach the age of 18. And then at the age of 18, they have the ability to have the whole amount. And there's a few things that are kind of alarming in that progression. So a trust usually works better. You get to name the person who's in charge. You can say that the person who's in charge can help the kids and the guardian of the kids with money from the trust, even when they're under the age of 18, but you've got someone who can help invest the funds, make sure that they're cared for properly, check up and make sure that the kids are doing okay with their physical custody arrangement. And sometimes people will name the same person to be the person who has possession of the children and possession of the funds. And then sometimes it's about 50-50. People will name different people to be in charge. And I always look at that as kind of a nice check and balance on both sides. You've got an adult who has care of the kids, who can kind of just see what the trustee is doing with the money and just make sure that there's nothing concerning. And then vice versa, the person with the money can kind of see what's happening with the kids and make sure that they think that they're being taken care of properly. So you get just a little bit more oversight there. The thing with providing for minor children in a will or trust is also that you can just have more flexibility. So instead of that blocked account situation where no one can really touch it and then the kids have full access to it, we can have all kinds of gradations of that. You can pick how much access, what the trustee can use the funds to help them with, when the kids are old enough to receive the funds, do they need to have some conditions attached to it? Do you want them to meet with financial planners? And, you know, you can build in a lot of things to a trust under your will that you can't if you say nothing. So it's a really good reason to have a will and to think through those types of things. Okay, and then when you're thinking about distributing your estate, so we've talked about who should be in charge, we've talked about the kid question, because that's a big question for people. Now we're talking about the stuff. How should the stuff be distributed out? And these are probably really common sense things for you, but good things to just be thinking about. So who are your primary beneficiaries? Among your primary beneficiaries, do you have minors that we need to set up trust terms for? Do you have a spouse who really does not know anything about finances and might need some guidance? These are things that we can build in. We've got your primary beneficiaries. What happens if something happens to one of your primary beneficiaries? Who should receive that share of the estate? And these are all questions that you're going to get asked, but I think it's important to just already proactively think about these things. Do you have anyone that has a special need or receives government benefits? Because that also is something that we can, you know, still get funds and assistance to the person, but we do it in a way that works best for their circumstances and maybe put somebody else in charge to help them out. Do you want some of your funds to go to a charitable organization? We want to say that. What's the size of your estate? Do we need to worry about the estate tax? We can plan with different ways of distributing your estate around the estate tax, at least to minimize it. And then kind of one of the primary things that I like to remind people of that's more of a practical concern is how difficult is your plan to carry out? I have found through the years that people love to get really complicated with like, if this, then I want this and this and this, and you know, and at the end of the day, the plans that work the best and have the most chance of success are typically the plans that are the simplest, at least to understand, because you might have really, you know, complicated thoughts and plans, but you have to think about the people who are going to be carrying these plans out. It's not you. They might not have a ton of time to do a whole bunch of intricate things. And so you just want to think about that. This plan that I'm putting out there, like I once had a client who had a business where she sold like toys and novelties and collector's items. And she had warehouses of these things. And she wanted so many different organizations to have access to this particular thing and this particular thing. And it ended up taking the executor many years to get through it. And for many of the organizations, the things that she was leaving them for them weren't very valuable to them. And so these are things that you just kind of want to think about. Is my plan practical? Will people be able to understand it and carry it out? Will it cost a lot to carry it out? Because that's another concern too. And do the people that I'm leaving these things to, do they want them? Those are all really good questions to ask. And I'd say if you have any of those questions, you can truly ask the people. if I do this, do you want it? You know, or if this is on the table, do you want it? Because people are going to be pretty upfront about that stuff. I found if you ask your kids, you know, we have this lake house, do you want it? Or we have this timeshare, you know, I want to keep it in the family. And then you hear from your kids, well, we don't have the money to pay the expenses of having it, and it would just be a burden to us. You know, that might inform your decisions about how you're distributing your estate. Okay, and then I'm just going to touch on it really briefly because this is actually a very complicated topic of should I have a will or should I have a living trust? And there's a lot of factors that come into play. So I can say right off the top, in Washington, a living trust can be helpful, but it's definitely not a no-brainer that you must have one in Washington. If you live in California, then it's a no-brainer. You must have a living trust, and attorneys in California who don't advise their clients to have living trusts can actually, you know, come under the question of like, is that malpractice that you didn't tell me that I should have a trust, because of all of the burdens and expenses that apply in California. In Washington, we have a probate system, which I'm going to talk about probate in a little bit so that you have a background of probate. We have a probate system that is pretty straightforward. And so avoiding probate, which is what a living trust does, is not always in your best interest in Washington. So when I'm meeting with just regular people with regular concerns who don't have like a real true grasp of a living trust and don't have a real true reason of like, oh, I want a trust for this reason, then the things I'm looking for as a clue to whether they should have one or not are, do these people have property in Washington and then real estate in another state too? That would be a 100% no-brainer reason why you would want to have a trust. And that's because when you have property in multiple states, each state has different laws about probate and estate planning. And each state has jurisdiction over the real estate that's located within that state. And all those things mean, when you put them together, is that if you have property in multiple states and you die, and probate is necessary, then we open probate in the state where you live, and then we have to find out all the other places where you have property, and we have to open up what's called ancillary probates in those other states, which means hiring other attorneys, dealing with other court systems, dealing with other laws and expenses that would apply in those states. And so if you had a trust and your trust owned all the real estate, it opts it out of the probate. So that would be a no-brainer reason. If you're very concerned about probate, you know, then a trust might be the way to go for you, because trusts do avoid the probate process. However, it's important to know, and a lot of people won't tell you, that the probate system in Washington is built on the trust administration system. So basically what our government has said is, probate shouldn't be something that prohibits people from settling estates. It shouldn't cost a ton of money, and it shouldn't be overly complicated, and there shouldn't be a ton of court oversight unless it's really needed. And so basically then what they said was, well, trusts work really well to transfer property, so let's make our probate system kind of based on that. If we've got a person who's been named in a will to be an executor, and we've got a valid will, and there's no concerns, then let's make this executor be just like a trustee. So they can now go out and kind of handle the estate without needing to check back in with the court on each decision, on each payment. But lots of times I have clients who are like, well, I want my estate to be private. I don't want my will to be filed with the court and become public record where somebody could see it, and they've got sensitive family issues for that reason. Then a trust might be better for you for that. Another reason that trust might be better would be if you have a complicated estate, a complicated, you know, set of assets and estate, and you have someone that you trust to be in charge. You could put everything in the trust, make that person that you trust be the successor trustee, and then they kind of can step in immediately. If something happens to you and you're not able to deal with assets, they can step in immediately and just start kind of handling things for you. If you die, it's a little, well, not much, but it's quicker for a successor trustee to step in and be able to have access to the assets of the trust than it is for an executor. And that's only because with an executor in the probate process, we have to go to court and get the person appointed before they can act. Whereas with a trust, you don't have to go to court. And so the person can almost immediately act as soon as the person has passed away or is incapacitated to serve. So those are kind of some reasons why a trust might be better. On the side of wills versus trust, I have a lot of clients where, they don't really understand the trust that well. Trusts involve maintenance because once you set up a trust, in order for it to work, it has to own the things that would otherwise go through probate. And as we go through life, we tend to forget and get sloppy with things. That's just the nature of humans. So you might set up a trust, you might do it properly, you might get everything that should go in the trust. And then as you go through life, you might sell your house, buy a new house, and forget that you need to tell the title company that you have a trust. And so now we have a trust that owns some of your assets, but then we have your house and it's just sitting out there in your name. And if you die, we're going to still open a probate to deal with the house. So it just depends on like how likely are you to do maintenance and review maybe every few years to make sure that things are up to date. And then with trust too, they're just they feel more complicated for people because they're not as common, so people aren't as well versed in how trusts work, and so sometimes that's overwhelming for people. So I think when you're deciding between a will or a trust, there are certain legal considerations to take into account, but then there are certain practical aspects of it too. Is this the right field for me? Do I feel intimidated by it? Am I afraid of it? I'm going to put it away and never look at it again. Or is this something that I'm totally up to? I'm a good student in life and I can definitely do this. Those are things that inform that decision too. So I'm sure there will be questions about this later. This is a good reason to point out that it is important to talk to professionals about your personal estate, what applies to you, what would be best for you, because you can do a lot of this learning, but it's kind of like looking up your symptoms on WebMD, right? Like, you might just have a headache, but now you think you have a brain tumor. And it's kind of the same with legal things. It's good to get some information, but then it's also good to sit down and talk to a person who can interpret those things for you, with you and your personal situation. And then just really quickly before we move on from wills and trusts, I want to make a note that personal property, so the stuff that you own, your jewelry, your artwork, family mementos, Christmas ornaments, cars, those types of things can be gifted to other people using a list form. So you can just write down on a list the item, who you want it to go to. You don't have to put that in your will or your trust. You can update and change that list anytime that you want. Certain people that I know write names of people on masking tape and put it on the bottom of things, and that would probably work too. But the list form is just Washington's way of acknowledging that you shouldn't have to go see an attorney and pay an attorney if you want to say who your dog should go to or who your Christmas ornament should go to if something happens to you. So just remember that that's part of the plan too. Okay, so we're going to switch gears and talk about powers of attorney for a minute. Powers of attorney are a document that impacts you while you're alive. So if I was in a car accident and I'm in the hospital and I'm in a coma and someone needs to step in and make medical decisions for me, or during that same time period, my mortgage is due and someone needs to be able to write the check to pay my mortgage company, that would be the person that I name in my power of attorney. So powers of attorney typically cover two types of decision-making, broad categories: healthcare decision-making and legal and financial decision-making. And one easy way to think about a power of attorney and what the person could do for you is kind of any document that you could sign for yourself, they could sign for you. So that kind of fits in those legal and healthcare categories. There's also a decision to make about when you want it to be effective. Most powers of attorney are only effective if you're not able to make decisions for yourself. That usually turns on a doctor saying, this person is not legally competent to make decisions. And then that would mean that your power of attorney would become effective and your agent would then have the power to start acting for you. In certain circumstances, though, it makes more sense to make the power of attorney effective immediately. And that would be, just off the top of my head, in circumstances maybe where someone has been diagnosed with a terminal illness and they are tired of dealing with their finances and they want somebody else to step in and just be able to handle it for them so that they don't have to think about that anymore. In that situation, we would most likely make the power of attorney effective immediately. So the person could just step in And then maybe even more importantly too, it's like we know healthcare decisions are going to have to be made. We don't know how quickly this thing is going to progress. And so now we've got someone who can immediately step in if they need to, without having to call a doctor's office and ask for a letter to make the power of attorney effective. We've already talked about how this affects you while you are alive, so it's a very important part of your estate plan. Something that is very important to think about is that the person that you name as your agent in this document has a lot of power. They can do anything for you that you could do for yourself. And in most cases, I'd say 99% of the cases, that's a really good thing. They have the power at the time that you need someone to help, and they have the ability to do it. And maybe less than 1% of the time, the person doesn't have the best intentions, and then they have a lot of power. So it's just something to keep in mind. You want the person, again, to be diligent, type A, around, answers their phone, like that kind of a person who's always there. And then if you ever have a concern about someone that you've named in a power of attorney, it's imperative that you contact your attorney and have that document changed, because we don't want to have people who have bad intentions be served up with a document that gives them lots of temptation to do bad things. It's just not a good thing. So those are really important things to think about. How do you pick the person to name? So I've already kind of touched on this too, but it's somebody that you trust, who is a good student in life, who knows you and knows kind of how you would make decisions. And this is a reminder to talk to people about how you feel about these things too, so that they feel prepared if they have to step in for you. Just like with a will and with the executor, if you can name one person as your agent and then multiple people as alternate agents, but in a priority order, that is practically the best answer. Just because they're not going to run into issues with banks. If there's a stalemate between two people who are named co-agents, it's not a problem. We've got someone who can make a decision. Sometimes decisions that people make under powers of attorney have to happen quickly. And so we don't want there to be any type of reason for it to stall out. And then just like I said, if you lose trust in somebody or there's a concern, you very much should update and change your power of attorney. So then we move on to the healthcare directive. And like I said at the beginning, this document is just a very short and to the point document. It basically says, if I've been diagnosed to have no brain activity and no hope of recovering it, or I'm terminally ill and I'm immediately in the dying process. So not have cancer, I'm in treatment, I've got, a prognosis of 6 months to a year to live. This is like, everything is shutting down. I'm at the very, very end stages. I'm not capable of making decisions for myself anymore or voicing my decisions anymore. So I'm trusting the agent that I named in my power of attorney to make my decisions for me. This document is a kindness to that person because it tells them, at least briefly, what your philosophy is about that type of thing. So healthcare directives are not the perfect answer to this problem. Because they don't give you a lot of options. When you come in to see an attorney, I think the law recognizes that lawyers are lawyers and we're not doctors. And so we're not the best at advising on like all the ins and outs of everything. So these are just big, broad brush strokes of, please continue giving me life-sustaining care, even if I'm not really there anymore, which most people use this document to not do that. Most people use this document because they do not want to end up hooked up to machines kind of indefinitely, with no ability to just be able to peacefully pass away. So this document, most people will say, please give me medication for pain. Please give me, if I need hydration to help with the medication for pain, great. But otherwise, please don't give me anything that will keep me alive forever and ever and in this state forever and ever. So that's kind of the purpose of it. And it definitely has to work with your power of attorney because we need someone who's authorized to make decisions for you who can then carry out the decision in this document. It's important to know that if you have a healthcare directive or an advanced health directive and you change your mind about something that's in there, you can revoke and change it. And really with any of your documents, if you change your mind and you're just like, oh my gosh, if this happened, I definitely don't want this, no matter what, then you can revoke it by, maybe drawing a line through it and writing revoked and signing your name. But you should also then follow up by getting a new document that says what you do want. So Okay, and then finally, kind of the last document to round out the process is the disposition of remains. The disposition of remains is very simple and straightforward. I think I mentioned this. It doesn't mean that you've prepaid for anything or that you've done anything proactively. It just simply says, if I die and nobody really knows what to do, I want to be cremated, and please put my ashes, fly them to Hawaii and pay for it with the estate, or, you know, put them at the haven of rest in Gig Harbor because I'd love to have that gorgeous view every day of my non-life. It just says what you want to have happen. I find all these things kindnesses to your family members because they're dealing with these documents at a time when they're going through a lot emotionally, and just to know what you want just takes some of those decisions off their plate. Decision fatigue is a real thing, and when you're in grief, then decisions can sometimes be impossible for people to make. So as much clarity that you can give people, the better. And this is just one of those things. And I would say one thing to keep in mind with all of your documents, and just a side note, is that these documents are very legalese. They're written using legal statutes. They don't sound like you. They don't, you know, they don't give them touchy-feely kind of feelings. So one thing that you can do to help with all of that is to write a letter that you can keep with your documents. The legally binding to make them do anything. It would just be to like give them a taste of you and why you made decisions. If you had philosophies that you want to pass on, if you want to tell them good job in life or I love you or any of those things, that would be the place to do it. But you can keep it with your will so that when they find the will, they're also finding something personal from you that just says like, hey, don't be upset that I put your brother in charge. I did that because I knew that it would be too hard for you to do, or you wouldn't want to do it and he needs homework to do. I don't know. You can say whatever you want, but it is nice. And when people do that, it makes a huge impact on their family members. So real briefly, I just want to touch on probate, because probate seems to be something that a lot of people have heard about, and most often they've heard horrible things about probate. Probate is only the process of getting what you have from your estate to the people who should have it and closing up all the loose ends. So basically, probate is taking the will to court, or if you don't have a will, going to court and asking that an executor be appointed. We're going to figure out in the probate process everything that you own, everything that you owe, and take care of those things. So if there's debts, we're going to pay them and deal with them properly. We're going to figure out what assets you have and get them to the right people or consolidate them. We're gonna make sure your beneficiaries get what they should get. We're gonna file a final tax return for you. Typically, people pass away inconveniently in the middle of a tax year, and that means that they still have an income tax return for that year to file, which we cannot file until the beginning of the next year. So sometimes when you hear people say, oh my gosh, probate has been going on for 9 months or 12 months, oftentimes the only reason the probate is still open is just because we're waiting for the ability to file that final income tax return, and the tax forms to file don't become available until the beginning of the next year. So, you know, we could pretty much handle and solve everything else in the probate and just be waiting on that tax return and then close it. But basically that's it. It's just ticky-tacky homework items to close up the estate and just close any loose ends that you have. Probate in Washington is required when you have $100,000 of assets or you have real estate. So either one of those things will get you to probate if you don't have a trust, and if no other form of transfer applies. So the $100,000 of assets has to be assets that are probatable assets, which means they don't have a beneficiary designation. They're just in your name and there's no other way to transfer them. Probate can happen whether you have a will or you don't have a will, because if you have $100,000 of assets that are subject to probate, or you have real estate, even if you have a will, the will still has to go to probate to get the person officially appointed as the executor. That's kind of the purpose of probate, just to get someone with authority to be able to sign off and close everything. And then probate would be required too if you have a living trust that you have forgotten and you've left something out of the trust, and now it becomes part of that $100,000 of assets subject to probate, or real estate that's in your name and not in the name of the trust. And I would just like to say, I guess, before I move on from probate, is that it is not as bad as people tell you. When probate is bad is when people are arguing about the will, or when there are major creditor issues and not enough money to pay, and then we've got complicating issues like a family home that people want to keep, and we just have to get through that process. That's when probate is bad. When you have a will, when your family members get along, probate is just a way from one point to the next point. And oftentimes it's actually nice because it provides a very straightforward process to get from A to B. The laws are very straightforward. The rules are very straightforward. So I would say probate is not a nightmare. You shouldn't be afraid of it, but you should have your estate planning done so that you're making sure that it can be as efficient and simple as possible. So there are other ways besides probate to transfer assets from you when you die to the people who should get it. And I've named a few here, but if you jointly own a piece of property with somebody else, or you have a bank account that you own together with somebody else, chances are when you die, the other person just becomes the sole owner of it. So that's joint ownership with rights of survivorship. The person gets it. If you're married, most of your assets, for most people, this is not true across the board, but for most people, are community property. And when you die, your spouse inherits your community property. And so that can be a way to transfer things without probate if you have a community property agreement. So you can't just rely on community property, you have to have an agreement. But having a community property agreement with your spouse means we would not have to open a probate at the death of the first spouse. If you name a beneficiary on an account, that account can go from you to the person that you want it to go to without the need for probate. So you have a life insurance policy and you name a beneficiary, or let's say you have a 401k or an IRA and it has a beneficiary named, that person will inherit that asset from you. No probate is necessary to take care of that. You submit the death certificate and paperwork to the company, and then they work with you to get it transferred over. Likewise, if you have a bank account or some other financial account with a transfer on death or a payable on death clause, that works just like a beneficiary designation and transfers directly to the person. And then I have trusts here too, because if you have a trust and you have assets owned by the trust, those assets do not go through the probate process. So these are all alternate ways that you can get out of probate. But a side note is that sometimes probate is the best way to get from A to B. And sometimes you can take a lot of crazy steps to avoid it, and then we still have to go through it anyway, or we take a lot of crazy steps to avoid it and we end up with problems. So one main problem that I see is when people have joint owners on their bank account. So, and just bear with me here, but a real common scenario would be for an aging parent to say, well, you help me with paying the bills, so I just want to add you to my account as a signer on my account. And you go to the bank to open up that account, or to add your daughter to that account with you. And you say, I want my daughter to be a signer. And the issue is that oftentimes the bank's policy is that when you add someone to an account, there isn't a designation for signer of an account. There's just a joint owner of the account. And maybe you have 5 other kids and you want your estate to be divided equally. You've added your kid to help you, but at the time that you pass away, that account becomes solely owned by the person who's listed on it with you. And so then we can still make it work out right, but you're depending on a lot of things. So you're depending on the honesty of the person who's inherited the account to want to get it to other people. Sometimes it can cause tax issues or gift issues for the person who's inherited it. And then again, the temptation for somebody to keep something that they kind of deep down know was not meant to just come solely to them. So there's a lot of issues like that when we're talking about other ways to transfer assets that people don't often think about. Another thing is that when you have assets go directly from like the institution to your beneficiary, sometimes that means the estate doesn't really have enough money to just pay the expenses that it has in order to close up. So your final income taxes, an attorney, maybe a CPA. And so these are things to consider too. Will there be some liquidity in my estate or my trust to help people be able to kind of wrap up these loose ends without all the money going directly to people who maybe don't want to kick in the money to pay for those things? Okay, and then kind of as a conclusion is who should be part of this process. So you're thinking about doing estate planning. there's a lot of people that you know or you work with that you may want to include in this process. So definitely you need to be part of it. You're the person making the decisions. I always suggest that an estate planning attorney is a really good route to go. There's a lot of online sources these days, and I will be the first person to tell you something is better than nothing. But generally speaking, working with an attorney who can ask you questions, who can interpret your situation, and then kind of put that out into documents, is you're going to end up with a better plan than if you do it online. So I would suggest an estate planning attorney. If you have a financial planner or advisor, you definitely want to tell them that you're doing your estate planning, so that if they have concerns or they know that you have a certain type of asset that we should address in the estate plan, they can tell you that, or they can connect with your attorney. If you have a CPA and we're doing like a living trust, or we're doing some tax things, then we want to talk to your CPA about it. If you have a personal banker or private banker that you work with, who would be very instrumental in explaining how your accounts are set up, and that some considerations that we might need to take into account in doing the planning. If you are working with a charitable organization and there's a gift officer there that you're working with, we want to talk to them about how to title the bequest that we might leave to the charitable organization. And in all of this too, there's a level of just informing people that you've done this, because estate planning documents are only so good as they can be found, and also that they work with your life. And so all of these people might have helpful pieces of the puzzle to put together. And then things to keep in mind: even when you have done your estate planning, you should not be like the run-of-the-mill person. You should, every 2 to 3 years, pull those documents out, maybe on a night when you can't sleep very well and your mind is racing. Pull those documents out and start to read through them and just give it the old gut check. Do these people still work for me? Is this plan still the right plan based on my circumstances? Have some things changed since I did this 15 years ago? Maybe I should address. So those are things to think about: pulling it out, reviewing it. If you have questions, you should contact your attorney. I get calls all the time, and half the calls I can easily tell people, oh, great, that's good to know. We don't need to make any updates to your documents based on that, but thanks for talking, and we had a nice chat. But sometimes it's a big change. You've gotten a divorce, you've had another child, you moved to another state, those types of things. You do want to see an attorney, and you probably do want to update your documents. And then my most important piece of advice, if you walk away from this with nothing else, there's 2 things. One is do your estate plan, but the second is tell more than one person where you keep those documents. Show them where you keep them, remind them periodically. Always keep your documents in that place, don't move them. Because in order for them to work, they have to be findable, and we just really want people to know where they are. So please tell multiple people, remind them, quiz them, write it in their Christmas card, whatever. But it's really important, and that's kind of the thing that falls off sometimes at the end. So that's about it. If you guys have questions, then I'm always happy to answer them. I put my contact information here, but I know that we are going to move into a question and answer session here. And it is my privilege to introduce Jeff Myers, who is a JD and an LLM, so even smarter than me by far. He's the Senior Vice President and Private Client Manager at Bank of America Private Bank in the Tacoma office. And he works with high net worth clients on estate planning issues. So he's a great person to help moderate the panel of experts that we're going to have answering questions for you. Jeff has been a member of the South Sound Plan Giving Council for 6 years. And for the past 4, he served as a member of the board. And so I'm going to hand it over to him now and let him help us answer all your questions.
Well, thank you so much, Brianne. That was a wealth of information, and a lot of those points really resonated with me as you said them. I thought, yeah, that's a great point to bring up. That's also a good point to bring up. Actually, I have a checklist. They're all good points. Anyway, so on our panel today, so that we don't have to listen to me much more, we have, of course, Brianne available for questions, but we have 2 others who I'd like to introduce briefly. The first is Christy Upton. Christy is a certified public accountant. She has her own South Sound practice in beautiful Tumwater, Washington. She's worked with several different CPA firms during her career, including Armour Vickerman, Armour & Associates, and most recently in Frost & Company. She's a graduate of St. Martin's University with a business degree in accounting. And I was able to pry this away from her. She said that the reason she started her own firm is to have the ability to dedicate more time towards serving clients and their families with personalized service and through planning strategies. So I thought that was great. And just wanted to share, thank you, Christy, for joining our panel. Rounding out the panel is Gary Brooks. And he has some of his bio right there. I'm going to read it. CFP Mission Wealth, right in his Zoom picture there. Gary's a partner and senior wealth advisor with Mission Health, a nationally recognized registered investment advisory firm. Prior to becoming a partner, he owned an independent financial advisory firm for a number of years. He previously worked at Russell Investments, and he started his career just like I did with Major League Baseball. No, that's not me. I think that was only my wish, that I would start with a Major League Baseball editor at CBS Sports and a sports writer at the Tacoma News Tribune. You might recognize him from his monthly personal finance column, also in the Tacoma News Tribune. Gary is graduated a Bachelor of Communications with University of Puget Sound, and he is a chartered SRI in addition to being a CFP, Certified Financial Planner. So he has at least as many letters after his name as I do mine. And so we are your esteemed panel. And do we have some questions that we want to open the floor up to? Is that, or do I have, yes?
We do have some questions. Yeah, so I'll just go ahead and feed you all questions from the chat or from our registration form that people submitted in advance of this event. Let's start it off with, we've gotten several questions about finding quality professionals, and this includes people that can act as an executor or folks that are local attorneys with estate planning experts. So if you all can speak to that, finding quality professionals to assist with this process.
And this is where it's completely organized, because if we were in a room, we would have secret hand signals that we would give to say, I'm taking that question. But since we're on Zoom, we don't get to do that. So I'll start and then I'll pause, and then another member of the panel can jump in, or I'll pause now. Oh, that was my pause. I'm going on. I think that the best answer is, because of what Brianne said to us, hey, procrastination is our biggest challenge here. So do something, right? How do you find a plumber? You look on the internet. I mean, it's not the best way to find necessarily an attorney, but if you know you're trying to find an estate planning attorney in the South Sound, I would put that in a search for the internet and see what you can find out. Of course, if you have someone who helps you with your taxes, if you have a CPA, if you have a financial advisor, if you have a family friend who's an attorney who you know they don't do that, but they might be connected. I recently had somebody had a criminal situation. They said, oh, right, Jeff, you're an attorney. And it's like, yeah, I'm not going to help you with your criminal thing because that's not my area of expertise, but I might know somebody. So that'd be my suggestion. And then just the other part is the executor is like, again, that's a procrastination thing. And I'm guilty of procrastinating as well. So I'm speaking from that perspective. But think maybe about who's going to care for the kids, a guardian for the kids. If that's something that's important that you put in your will, you're trusting your kids with them, maybe you can trust your estate with them. Gary or Christy or Brianne?
Well, I would just say too, other professionals are a great source of finding other professionals. So just if you have a CPA, financial planner, they usually know people and have worked with them, so they actually know the track record of the person. If you have friends who just did their estate planning, same thing. I get tons and tons and tons of referrals from clients of just like their friends, their neighbors, their family members. But online, if you are going to look online, there are a couple reliable sources that you can go to. So one would be, we have the Tacoma Estate Planning Council in this area, and we have a directory there of attorneys. I know all the estate planning attorneys around here. I can't even think of one that I wouldn't trust to do my estate plan for me. So I would trust all of them to do the job just great. I would suggest calling and talking to the person or just the office and making sure that you get a good feel. You can always call a couple and just ask questions about cost and timeline and philosophy. And that's a great way to make sure that it's a good fit for you. Same with fiduciaries. So if you're looking for a trustee or an executor, a lot of us professionals will have companies that we recommend, but if you're just going straight from the internet, I would call and talk to them and ask them real practical questions. Like, if I'm using you for the trust for my kids, you know, what does that look like if they call you and need something? How do you charge for your services? How long does it take you to get back to people? I mean, those are just kind of the basic things. The other online resource, if you're not looking directly through like the Tacoma Estate Planning Council, would be, there's a website called AVVO, AVVO, and that has very good resources for finding attorneys in the area that you want them to be in, and also the location that you want. And then you can browse through client reviews and colleague reviews of the person, and then call a few. That's often how we find attorneys in other states where we don't know someone personally, is we will go through those, narrow it down to 3, contact the 3 different offices, and ask a lot of questions to make sure that we get a good feel for how they're going to operate.
Okay, Gary or Christy?
Yeah, I think I'd just add that especially if you are in a situation where you're considering the Washington State estate tax as part of your estate planning, finding an estate planning attorney who also has some expertise in the tax situation can be helpful.
Great. Okay, Christy.
Hi, absolutely. I think referral sources are the best. A lot of the times, if someone works with a professional in some aspect of their life, and calling on that professional who knows other professionals can help refer you to someone that can help you.
Great, thank
Melissa?
you so much. Yes, and I am gonna just reiterate something that Evelyn put in the chat as well. The Leave 10 South Sound website, we do have professional advisors that are champions of our work. And so if that aligns with your values, you definitely can visit the Leave 10 South Sound website and see some folks who are committed to our cause. All right, next question. We have, please give some examples of charitable gifting via estate plans or wills. And can you explain different assets such as homes, collectibles, business interests that can also be gifted to charities?
I guess I'll jump in there for a
yes,
moment.
we can, and Gary's going to lead us off. Thank you, Gary.
Okay, yeah. Certainly you can be creative in your giving in a variety of ways. And as you mentioned, it doesn't have to be just financial assets. You can think about homes or antiques or paintings or whatnot. Most charitable organizations are willing to have conversations about those things. It needs to be something that could actually be sold, though, and liquidated in some form to actually benefit the organization. If it's going to be a real pain in the neck to actually move that asset, then they may not be quite as interested as you would hope. That said, you can make bequests to charitable organizations in your will. There's more flexibility of a variety of things you can do in terms of giving while living rather than waiting until your estate event, right? In that regard, you have a wide variety of options, some of which can pay you back in forms of retirement income, in addition to being, donations that bring tax benefits. It doesn't have to wait until the will or the estate event to have a charitable conversation. In fact, it's probably much easier to communicate your wishes and identify the best routes for them to have that discussion well before the estate event.
The only thing I'd add, thanks, Gary, that's great. The only thing I'd add before Christy responds is my suggestion there is if you have a particular charity that you want to benefit, get them involved, or your local community foundation can have a lot of expertise at that, because as Gary said, there are certain things that you're going to want to know about your gift, and they're going to help you with those questions. Christy?
Right, so one thing I want to point out is that in the will or trust document, if the charity isn't listed, then as a beneficiary, it is not tax deductible. So sometimes we have where the beneficiaries who are children know that mom really liked to donate to the Humane Society. They will do a donation out of heart because that's what they like to do, but they completely lose the tax benefit from it. Another thing I want to discuss is regarding gifting while you're alive. There are a lot of strategies with that, especially to charities. So I definitely suggest you talk with a knowledgeable advisor regarding how you gift. First off, if you're subject under, let's say you're taking required minimum distributions out of your IRA, gifting from your IRA reduces your ordinary income tax rates, and you're able to get more bang for your buck. for the charitable donation as far as tax savings go. Some people will liquidate items out of their investments to give to charity. It's a better method to just gift the capital gain stock to charity. So there's a lot, and there's a lot more to that, but when you're going to do charitable gifts, definitely speak with advisors so that you get the best bang for your buck.
Thank you for that, Christy. Melissa, back to you. Sorry, we'd let Brianne, but we've heard Brianne. We have to move.
Okay.
Next question.
Okay, perfect. Let's go ahead and hear from you all about your perspective on tools like Free Will. For those of you that don't know, that is an online tool that kind of helps question folks and generate like a draft of their will. So we just wanted to hear your thoughts on using tools like that and how that kind of impacts your role.
Well, let me jump in first on there, and then I'm sure all the panelists want to address that, because if we talk too good about free will, then Brianne's out of a job. And that's not the case at all. I have people who over the years of my career have sent me their lovingly handwritten or even self-typed up wills where they've told me what they're going to do and how they're going to do it. And I have strongly encouraged them to have somebody take a look at it. Or the recent conversation I had with my aunt, my loving aunt, I love her dearly. She said, now I don't have time to change my will. So I'm just going to take my pen and I'm going to cross some things out and I'll initial it and that will amend my will. And I said, no, it actually won't. And she said, why did I even call you? So I think that there are benefits, especially when you're comparing it to the alternative being you're doing it yourself. The last thing you want to do is spend time and energy to produce a document that isn't going to be followed and is going to be thrown out. So I think it can be better than the alternative, but it can also be a good place to start. And I've had situations where people have come to me and said, I used some sort of computer to create this will. And I've said, well, that's interesting. I can see how it's valuable, but these are some areas that you're going to want to have a look at with an attorney. So that's my 2 cents. Gary?
Yeah, the number one flaw with any online templates is just that they do not get signed and witnessed appropriately, making them invalid. So they can be great to steer the conversation, but we need to make sure they're actual valid documents.
Absolutely. My aunt also said that she was going to have her will notarized. And I said, well, there's a sort of a thing with witnesses. She said, yes, I know. Okay. Brianne?
Yeah, so I have a couple of things. One is something is always better than nothing. So if I've seen free will be very, very effective in a situation where someone is like an emergency has happened. They are not able to come to an attorney's office and they don't have a lot of time for an attorney to make time to come to see them, then free will could really be a good bridge there to make sure that their stuff is done. And they do give you advice about how to sign it and all of that. So if you're a good student, you could probably make it work okay. I would reiterate that in my practice, I do see a lot of people who've used resources like Free Will to get started and then gotten scared away because they don't know if they're answering the questions correctly, or they've used it as a way to outline their thoughts and bring me their thoughts a little more formed than just like coming loosey-goosey. So anyway, I don't feel threatened by free will. I think it's a really good thing. As we know, there's more than 60% of the population who doesn't have a will, and I feel that I will, knock on wood, not ever be out of business or without work. So I can't help everyone, even though I would like to. And so any resource that you could use that will get you closer to having a will is good. I do see a lot of mistakes being made. And then Gary's point about them not being signed properly, and Jeff, the notarization versus the witnessing. The thing with wills is that there are a lot of requirements for how they're valid. And so people do mess that up occasionally.
Christy, you want to share?
Hi, yes. One thing I find with free wills is they very rarely have any tax provisions or tax planning involved with them. The most common free will I see is an I love you will. Typically, the clients are worth between $2 and $4 million. What ends up happening, all the assets go to the surviving spouse upon the first to pass. And with that, there's no tax planning strategies to shelter any of the assets they have from Washington estate taxation. So what happens upon the surviving spouse is they're looking at a $4 million estate. The tax hit to the beneficiaries is about $250,000, and their only solution to save the beneficiaries the $250,000 and keep the wealth within the family is to gift. And that can be a really hard decision for the surviving spouse because they don't know how long they're going to live. They need to make sure that their long-term care needs are taken care of. So it can create a lot of stress for the surviving spouse, and also be very costly to your beneficiaries with just a free will that has no tax provisions in it.
Thank you all. Melissa?
All right, next question. Can you have a different person for a healthcare directive and a financial power of attorney?
No, sorry. Next question. Yes, you can. In fact, what happens in a lot of families is there's somebody who might be good with mom or dad and good with the money, and then that person isn't necessarily good with mom or dad with health things. For example, I didn't want to deal with health things. I'm happy to deal with money for mom and dad. But also sometimes in families, you divvy that work up so that it's not just one child doing everything. I'm going to take that one. Let's get another question in before we run out of time.
All right, so the next one is, what sort of estate planning does one need who is low income and has less than $5,000 to $10,000 in assets?
So it's there's two ways. Things that Brianne talked about is that guardianship is still necessary, even if you're modest means, even if you're not going to look to Christy for some tax planning, you still want to, if you want to, and most parents want to decide who is going to take care of their kids. So I think it's a very important thing there. And then the second thing I think is that a lot of times you see self-help estate planning, or what I refer to as self-help estate planning, where you have 3 kids and you have 3 bank accounts and you have 1 kid on each bank account and you try to keep the accounts the same so that at your passing, each kid gets 1/3 of what you had. So there's the practical mechanics of what people do. And then it's what we might have as a goal. So I think I'd start with where we started this conversation, which is, hey, it's good to have a plan and good to have an estate plan that's going to help you, even if you're in modest means.
Maybe then free will would be a great resource to use to put a will together so that in the event that for some reason the court needs to get involved, there is a will that can be relied on with the person who's appointed as the executor.
Okay. Melissa.
Great. So our next question has to do with creating an LLC or corporation to potentially serve the same purpose as a living trust. So can you speak to gifting by creating an LLC or to share ownership?
I won't jump in on this one.
So you definitely can. Oh, go ahead,
Sorry.
Christy. Yeah.
Christy, you got it.
Okay, for estate tax planning purposes, when you're dealing with a taxable estate, creating an LLC in real estate and then gifting portions of the real estate effectively removes assets from your taxable estate, it kind of gets into a complex area of tax, but when you reduce your control of an asset, you reduce its value. So you gift portions of your real estate that's formed as an LLC to fellow family members. You then are reducing the value of the LLC in your estate. Regarding the gift amount, let's say you're only gifting, 2% a year, 5% a year to your beneficiaries, that value is close to zero, very little. So for gift tax return purposes, which lowers your estate exclusion, it's a great estate tax planning strategy. It depends though too if it's a taxable estate or not. So if it's not a taxable estate, sometimes people go a little overboard with the LLCs and the gifting, and what it then creates is a lower basis if it's ever sold. And so then you're paying more taxes because you're paying higher capital gains taxes as opposed to just paying Washington taxes or just keeping it in your state as a whole. So it's really intricate. It really depends a lot upon the underlying asset in the family. and what they plan to do with it.
I would just interject about the question. I think that was also part of that whole thing, which is, will that get us out of probate or the need for a living trust? And you can put assets into LLCs and corporations for tax reasons, for change of ownership, for management type reasons. It's not going to necessarily get you out of probate, and that's because the asset is still an asset that needs to be transferred and doesn't have another independent way of transferring. Now, if you have out-of-state property and you put it into an LLC, then often we can just deal with it in the Washington probate versus opening another probate somewhere else, because we're dealing with transfer of LLC ownership versus transfer of property ownership. But it doesn't necessarily get you out of probate.
Gary, did you want to chime in?
Nope.
Nope.
That's covered
Okay.
well.
And I think that the last thing I'd say is LLCs are good for what LLCs are good for, and trusts are good for what trusts are good for. And you're not going to say, hey, I'm more comfortable with LLCs, and so I'm going to make it do what a trust would do. So I think that there are specific jobs for each of them.
Okay, I think we have time for just one more question. We had someone who was hoping that you all would cover trust for pets.
Sure. So the first time we had a situation like that, as I recall, it was on the peninsula, and we were supposed to give a cat to a cat shelter. And so we were excited because we had a cat and a place to send the cat. And then they said, how much comes with the cat? And we said, well, it has one of those towers that you have with the scratchy, and it has some of the thing for the cat to go to the bathroom, and maybe we have some food. And they said, you misunderstand. What's the money that comes with the cat? And we said, well, there is no money. What were you looking for? We were looking for $25,000. And we said, but the cat's like 11, 12 years old. Yes, $25,000. Yeah, so that's my pet story of pets and where they go. I'll stop talking now because I'm sure the other panelists want to jump in.
Well, a pet trust. So people often who have pets have strong opinions about where they should go, right? And you can't give money to a pet to keep the pet, but you can give the pet and money to an organization or a person. And oftentimes that a trust is a way to do that. Or sometimes it doesn't make sense to set up a trust to care for a pet. So then you just give the money and the pet to the person or the organization. And that has the ability to go awry, but most of the time it doesn't. Most of the time it goes well.
And I would go, Brianne is exactly right. And I think that I would structure it in my mind that I'm giving a gift to the caretakers of my pet, and they're going to use that gift however they want to. I also had one that was a trust where we had to administer a trust after the person died for a number of years because they had to show receipts for the care before we could close the probate. Yeah, that's also not a very good. Just find some friends who are going to take care of your pet and leave the friends the money, and best wishes, I think.
I have
Sorry
a
to be
really
so hard.
a great story I never get to share. And that is, there was an attorney in town many years ago who wrote a will for someone, and the woman just loved this attorney and just thought he was the best and wanted to leave her dog to him and also a monetary gift, which she did, and she died. And he promptly euthanized the dog and kept the money and was disbarred. So don't leave your attorney your pet.
So that's sort of a balance, right? So you want to use an attorney to do your will, but not take care of your pet. Okay.
We're running out of time, folks. So first, let me thank Brianne Kampbell. What a wonderful gift you've given everyone today with your presentation. And thanks to our panelists, Jeff Myers, Gary Brooks, Christy Upton, for all your thoughtful comments and insights. Let's show our appreciation with a little air applause, please. These are great people, and they donated their time to be with us today. This program was the brainchild of the Leave 10 South Sound Community Outreach Committee. The co-chairs were Sherry Stanton, KBTC Public Television, Sharana Kilden, Tacoma Pierce County Habitat for Humanity, and committee members Regina Bellady of U.S. Bank, Becky Brummond, she's a plan giving marketing specialist. Hella Burlingame, TVW, Beverly Cox from B. Cox Planning in Gig Harbor, Katie Evans, Hilltop Artists, Brenda Gaspar from the Lindquist Dental Group, Kurt Jacobson, Community Volunteer and Marketing Specialist, Carol Kowalski, Kitsap Bank, Jonathan Lindsay, again, TVW, and Shelley Buck from FLS Financial Services. Of course, Evelyn and I were part of that. It goes with the territory, I suppose. So Leave 10 South Sound does not fundraise. We support all our nonprofits with an interest in plan giving, and we offer supporting information and education to nonprofits and professional advisors who want to increase their knowledge and ability to assist clients and donors in reaching whatever philanthropic goals their donors and clients have. There is a complete section on the Leave 10 South Sound website, by the way, to assist individuals or donors. So you can point them there with complete confidence. So all of the materials, educational offerings, and online toolkits are offered at no cost on our website. All of our expenses right now are being covered by the generous support of our sustaining partners, Greater Tacoma Community Foundation, the Community Foundation of South Puget Sound in Olympia, the Ben B. Cheney Foundation, and the Multicare Foundations. We are grateful for this local and ongoing financial support. Access to our website is very simple. All you type in is Leave 10 South Sound into your favorite web browser. The site has general information on the landing page, immediately useful materials and toolkits, as we said, under the designated tabs, one for donors, one for nonprofits, one for professional advisors. When you get the bug and you finally want to become one of our champions, go to the champion section, sign up, and then talk to this initiative with your family, friends, donors, and clients. Leave 10 South Sound challenges your thinking with a single word: imagine. Imagine how our South Sound communities could be positively impacted by completing this one act of generosity, leaving 10% to invest back into those communities that made you who you are. If you still have questions, our professional advisors who can will stay around for a few moments afterwards to answer. And on behalf of the Outreach Committee of Leave 10 South Sound, thank you for attending and have a great finish to your week.